If you thought Washington's political theater was already dramatic, then last week's series of blockbuster Supreme Court rulings made it even more electrifying. These decisions support partially ending birthright citizenship, pausing refugee resettlement, freezing unnecessary federal funds, halting support for sanctuary cities, banning taxpayer-funded gender transition surgeries, and even mandating a ban on first graders reading LGBT-themed books. These rulings not only cleared the way for Trump's signature policies, but also triggered an unprecedented legal civil war, with conservative and liberal justices clashing so fiercely that even legal jargon practically dripped with gunpowder. At the heart of it all was one question: can a federal district judge stop a president's nationwide policy? On June 27th, in Trump v. Casa, the Supreme Court delivered a crystal clear and extremely favorable answer for the Trump administration: no. The case centered on Trump's January 20th executive order, issued on his first day in office, which revised rules on birthright citizenship. Under that order, only children with at least one parent who is a U.S. citizen or lawful permanent resident would automatically qualify for citizenship. That directly challenged traditional interpretations of the 14th Amendment. Trump's team argued that the amendment was originally intended to grant citizenship to children of emancipated slaves, not to be exploited for birth tourism. In response, liberal-leaning federal judges in Maryland, Massachusetts, and Washington issued nationwide injunctions, instantly freezing the executive order. But the Trump administration hit back, appealing to the Supreme Court. In a 6-3 ruling, conservative justices sided unanimously with Trump. They held that district judges had overstepped their power by issuing nationwide injunctions, something that Congress never authorized. For decades, a single district judge could halt a nationwide policy. The Supreme Court simply said that's no longer acceptable. This is a landmark ruling reshaping the dividing line between judicial and executive power. Justice Amy Coney Barrett, writing for the majority, was crystal clear. A court's job is to resolve the case before it, not to serve as a master switch for national policy. You may rule a government action unlawful as applied to the plaintiff, but you can't overturn it for everyone. Barrett emphasized that if liberals want to challenge federal policy nationwide, they must use proper class action procedures far stricter, and requiring proof that a group shares common legal grievances, not rely on a single judge's unilateral decree. Importantly, the ruling did not declare whether Trump's birthright citizenship order is constitutional. But it did strike down the injunction freezing it, prompting cheers at the White House, calling it a tremendous constitutional victory. Trump soon announced that not only his order on birthright citizenship, but also previously blocked policies like pausing refugee resettlement, freezing federal funds, defunding sanctuary cities, and halting taxpayer-funded gender transition surgeries could all proceed. Essentially, it hit the accelerator on his agenda. But even more explosive than the verdict were the courtroom fireworks, especially the direct exchanges between conservative Barrett and liberal Justice Ketanji Brown Jackson. Justice Jackson, a black woman nominated by Biden, responded with a fiery concurring dissent, even quoting "No King" slogans from protests against Trump. She warned that in a constitutional system, nearly every government act must be subject to legal challenge. She accused the majority of obsessing over legal technicalities while ignoring the larger scheme, arguing their reasoning risks unchecked executive power. She characterized their debate over judicial authority as legal wordplay that obscures the fundamental question: can courts compel the government to obey the law? Barrett shot back with textbook-level mockery, rare in a Supreme Court opinion, saying Jackson's argument was so far-fetched it wasn't even worth refuting. She accused Jackson of hypocrisy, fearing a presidential king while advocating for judicial supremacy. Barrett slammed her for ignoring power limits and used Jackson's own words to retort, "Neither presidents nor judges can act lawlessly." That Trump v. Casa case was just the first wave in a conservative supermajority sweep. It was followed by additional 6-3 rulings, reinforcing legal theory. 1. Upholding the ban on gender transition care for minors. This Tennessee-based law prohibits doctors from prescribing puberty blockers, hormones, or performing gender transition surgeries on minors. The court sided with Tennessee, agreeing the law was based on age and medical purpose, not discrimination based on gender identity. Liberal justices again publicly read strong dissents, arguing it was discriminatory and emphasizing the benefits of such care. Barrett's majority opinion went further, stating that transgender status is not a constitutionally protected category and that recognizing it would entangle courts in legislative policymaking. Tennessee GOP Senators Marsha Blackburn and Roger Marshall hailed the decision as a victory of common sense and biology, promising to push for a nationwide ban. 2. Resuming deportations to third countries. A Boston district judge had blocked Trump's policy forcing migrants to resettle in safe third countries. The Supreme Court reversed in a 6-3 decision, allowing the policy to continue. Liberal justices warned this could endanger thousands, but conservatives countered that many of the migrants had committed crimes or posed threats. 3. Parental rights in LGBTQ, inclusive school materials in Montgomery County. Maryland public elementary schools introduced required LGBTQ-themed books. Parents from Catholic, Orthodox, and Muslim faiths filed suit after their children couldn't be opted out. The court 6-3 sided with parents. Justice Alito wrote that mandating lessons conflicting with religious beliefs without opt-out options violates parental religious freedom, likening the forced instruction to cult-like indoctrination. These rulings collectively, especially the one on transgender medical care, expose what conservatives call the Democrats' democratic paradox. The Tennessee law was passed by a democratically elected legislature reflecting public sentiment. Polls show nearly 60% of Americans, including over 1/3 of Democrats, favor banning such care for minors. The Supreme Court did not forbid transgender health care, but affirmed states' rights to regulate it. Yet Democrats erupted in so-called anti-democracy outrage, highlighting how they champion democracy until outcomes they dislike emerge from it. Ultimately, the Supreme Court this week curtailed district judges' power. Nationwide injunctions no longer stand. Empowered state legislatures gave them authority to regulate social policy, especially for minors. Bolstered parental rights, especially in education and religious matters. Expanded executive flexibility, particularly on immigration enforcement. But the drama is far from over. Trump v. Casa dealt with procedure, not constitutional substance. Justices Barrett's arguments, Sotomayor's on-court dissent, and Jackson's "No Kings" outburst signal deep divisions. The court has become the eye of the political storm. It's no longer a shield from turmoil, but the source of it. And the fireworks resumes October 6th. Who knows what explosive ruling will come next? I'm Sheep Counsel. If you enjoyed this, like and follow. Thanks for watching. See you next time.